Test number 6, question 1. Which of the following sentencing procedures is valid? A. The court must pronounce sentence in every case where a conviction is entered, and that is the correct answer. B is wrong because sentence must be imposed on every count where a conviction is entered. Sentence can be imposed against corporation, as you'll see later, in the absence of counsel. And the court may not dispense with the requirement that defendant be personally present at sentencing for any felony. The defendant has to be personally present at sentencing. 2, sentence may be pronounced against corporation in the absence of counsel. B, if defense counsel fails to appear on the date of sentencing after reasonable notice thereof. 3, select all correct statements regarding the victim of a felony who wishes to make a statement at sentencing. Now, basically, this was a study question. The one that was wrong was number 6 because it's a may. So let me read them all as if they're all true, but actually 1 through 5 and 7 were true the way they were written. So if you just change the word must to may in number 6, this is a good study question. 1. If requested at least 10 days prior to sentencing, the court shall accord the victim of a felony an opportunity to make a statement with regard to any matter relevant to the question of sentence. 2. The court shall notify defendant no less than 7 days prior to sentencing of the victim's intent to make a statement. So what does that tell you? If the victim waits till the last minute, the court only has like 3 days to notify the defendant because he's got to be notified 7 days in advance. 3, if defendant did not receive at least 7 days notice of the victim's intent to make a statement, the defendant may request a reasonable adjournment. Does not say the court must grant one. It says the defendant may request it. 4, the court must accord the prosecutor, defense counsel, and defendant the opportunity to make statements at sentencing, and statements by prosecutor and or victim must precede statements by defense counsel or defendant. So it's the opposite of summations. Summations, defendant goes first, then people go last. At sentencing, people go first, victim goes first, defendant and defense counsel, they're last. 5, if the victim does not appear at the time of sentencing, the right to make a statement is waived. 6, the court may, that's why it's wrong, either before or after receiving statements, summarize the factors it considers relevant for the purpose of sentence and afford an opportunity to defendant or his counsel to comment thereon. 7, regardless of whether the victim requests to make a statement where a defendant is committed to upstate prison for a violent felony, sex felony, or a homicide, the prosecutor, within 60 days of imposition of sentence, shall provide the victim with a form on which he may be demanded to be informed of the escape, parole, release, etc. of the defendant, and a DCJS form on which he may demand to be informed of any petition to change the name of such defendant. So both of those forms, just make sure you know it's 60 days, violent felony, sex felony, homicide, and the prosecutor has the responsibility of doing it. 1, 2, 3, 4, 5, and 7. 4, except where a sentence of death is pronounced, which doesn't exist in the state, but whatever, a certificate of conviction or a sentence and commitment showing the sentence pronounced or a certified copy thereof constitutes the authority for execution of sentence, and no other authority is necessary to justify or to require execution of sentence. So answer is B, certificate of conviction or sentence of commitment or a certified copy thereof. 5, this is true. A sentence of commitment or certificate of conviction is not defective for failure to deliver an order of protection issued against the defendant to the person in charge of the facility where the defendant is committed to at the time he is delivered there. 6, whenever an indeterminate sentence is imposed, a certified copy of the minutes of sentencing must be delivered to the person in charge of the institution to which defendant has been delivered within 30 days of imposition of sentence. So the person is sentenced, the court reporter has to do the minutes, 30 days, imposition of sentence, certified copy of the minutes of sentencing. 7, select the incorrect statement. regarding reporting of certain criminal convictions. A. So A is false because it's the prosecutor in this one, not the court. So when we have teacher sex offense, it's prosecutor notifies the Commissioner of Education. So it would properly read like this. Upon conviction of a teacher for a sex offense, the prosecutor shall provide notice to the Commissioner of Education. That tells us all the others are correct. B, upon conviction of a licensed physician, PA, specialist assistant, or practicing medical resident, the court, so the court that sentenced the person, shall provide notification of the conviction and sentence to the Office of Professional Medical Conduct. C, whenever a person receives any sentence of imprisonment, the court shall notify the Commissioner of Social Services, who in turn shall notify the appropriate local Commissioner of Social Services. So basically, you cannot get welfare while you're in jail. D, whenever a person under 19 is sentenced for a crime, the court shall provide notification of the conviction and sentence to the designated educational official to the secondary or elementary school in which such person is enrolled as a student. So something to note about this is that it's not part of the student's record. It's only used for successful school adjustment, re-entry to the community, and some other crap. One other thing I forgot. And it's not part of their permanent record. It's kept separate and apart from the school student records, and it's destroyed when the student is no longer enrolled in the district. So if the crime happens when they're in 8th grade, they're convicted as a juvenile offender or something, there's a crime, then they go to high school, it doesn't get destroyed until after they finish high school. So it's the school district. 8. In cases where someone is convicted of an offense where fingerprinting is required, the court may not pronounce sentence until it's received a fingerprint report from, and it's either B or C, either Police Department or Division of Criminal Justice Services, which is DCJS. 9. This is an important question to know about the HIV testing because it has 2 time rules. I would not waste my time memorizing the other stuff about it, but make sure you know these 2 time rules. Before the public health law was amended, it did not require that the test was disclosed to the person that was actually tested. Now the public health law says if you're going to perform this test on someone, they also have to be notified of the results. So it's actually confusing in the statute. I think if there's going to be a question on this, it's going to be these 2 time rules, so make sure you know them. Select the correct time rules for HIV testing. Tests must be requested in writing, filed within 10 days of conviction. If court orders testing, tests must be performed within 15 days of such order. Note results are confidential and only given to the person making the application and the defendant, not the court. So, filed within 10 days of conviction, 15 days for the test to be performed. 10. Not less than 1 court day prior to sentencing, the pre-sentence report shall be made available to defendant, defense counsel, and prosecutor. And yes, I spelled the prosecutor wrong. So the answer is B, 1 court day. 11. True. The court may always order pre-sentence investigation and report, even for a fucking violation, I guess. 12. True. In certain circumstances, a pre-sentence investigation may be waived on consent of prosecutor, defendant, and court, and including within the city of New York only, a definite term of imprisonment that is 365 days or less. That actually has happened in New York City, where someone got like an 8-month sentence and everybody waived it. But you can only do that in New York City. But make sure you understand when it can be waived. 13, a short form probation report may be used when B, defendant is convicted of a misdemeanor, period. 14, a pre-sentence memorandum of a prosecutor shall be served upon the defense at least 10 days prior to sentence date. Okay, so we have 2 10-day rules in here. We have the 10-day rule for the HIV requesting the victim, whatever, that's 10 days, and then at 15, this is the pre-sentence memorandum of a prosecutor served on defendant at least 10 days prior to sentence date. 15, following misdemeanor convictions where no pre-sentence report has been ordered and no sentence promised, the judge may impose one of the following sentences, and the answer was C, 90 days jail. So it can't be in excess of 90 days, but a 90-day sentence is okay. There's a pretty good video I have about this, so if I could find it, I'll send it to you. 16, a person is convicted of 1 misdemeanor and no other offenses. What can the court impose without ordering a pre-sentence investigation and report? So the answer was B, conditional discharge. because it said prison in excess of 90 days. That's no good. Other examples would be prison 90 days or less, conditional discharge, a fine, and unconditional discharge. 17. There are two things that must be included in an abbreviated or short form probation report. One is, quote, any matter relevant to sentence that court directs to be included in particular cases. Select the other information the agency must include in such short form report. And the answer was A, the extent of the injury or economic loss and the actual out-of-pocket loss to the victim, as well as the amount of restitution or reparation sought after they've been informed of the right to seek such money. This other stuff is included in the regular report, not the short form report. 18, select true statements regarding interim probation supervision, so IPS, and one is wrong because the court does not have to get consent to the prosecutor. They must consult with the prosecutor, okay? Not consent. 2, before placing the person on IPS, court must get consent of defendant, so that's true. 3, a person must be eligible for a sentence of probation, true. Generally cannot exceed 1 year. And 5, if a defendant is participating in a substance abuse program, the court may extend IPS 1 additional year, but only with defendant's consent. So if you want to cross out get consent and write consult with prosecutor, then you can make this into a study question and they'd all be correct. But as far as this question, the answer is C. 19, this is a false, okay? And I'm going to read it as if it were true, but because it said shall not, it was false. The act of seeking health care for someone who's experienced a drug or alcohol overdose or other life-threatening medical emergency shall be considered a mitigating factor in any criminal prosecution for drugs, Mary Jane, paraphernalia, or alcohol-related offense, and that is true. It will be considered a mitigating factor if it's presented as such, but the question, the way it was written here, the answer is false. 20. Probation departments shall provide a copy of pre-sentence reports prepared in the case of individuals licensed pursuant to Title VIII of Education Law to the State Department of Health. Such reports shall be in writing, may be submitted electronically or in hard copy, and shall be accumulated and forwarded every 3 months. And please just take a look at what's got to be in it. The answer is A, every 3 months.